So our last item on our agenda is a fireside chat highlighting a new legal framework for tribal health data sharing based on experiences with the Alaska state government and the Alaska Tech. Here to discuss her experiences and describe this legal framework is Chris Alibrandi O'Connor, Managing Director and owner of CAOC Consulting. She is an attorney and an area of focus and expertise with data sharing between federal or state public health authorities and tribal public health authorities. And joining her to moderate this chat is Carrie. So please join me in welcoming Chris and Carrie.
All right, this is the end of the day. So we have one vote for sitting here and one vote for walking around. I may win eventually.
I'm not sure where the fire is for a fireside chat. But we thought it'd be nice to kind of close out the day with essentially some storytelling, right? So, and a chance to kind of hear about some things that have worked. So for those in the room, how many of you have ever been involved in some way in data sharing? Like a lot of hands. How many of you have had some kind of issue with setting up data sharing, or you've run into challenges, right? All the same hands went up, right? It's a very common problem. And so being able to share an example of something that worked, of some success and some new tools that might be able to help other folks on that journey. We're excited to have Chris here to share some of your experiences. So to start us off, can you tell us a little bit about kind of the context in Alaska specifically, some of the challenges that they were encountering, and then how you got involved?
Sure. And first, so I want to start by saying that I was a consultant who was hired by the state of Alaska to help them do a better job of sharing data with the Alaska Native Tribal Health Consortium and their tech. So the first thing I want to do is recognize it's their story. So it's the story of the people who worked primarily on it were on the state side, Lindsay Cato, Christy Lawton, Eliza Ramsey, and Leah Farzan. And then on the tech side, it was Weatherpot Devon, Peter Reckmeyer, Ellen Provost, Larita Lactonen Ward, and Pete Peterson. But I'm the one who's here, so I'm going to tell you about it. So the state really wanted to share as much. The leadership of the state really was at a point where they felt like we want to share as much data with the tech as we are legally permitted to do. So that was where they started from. But the issues were that the state didn't have any kind of a policy. It didn't have any way to standardize those requests. So when the tech made requests, the request went to whoever the data steward was. So the tech could get a different response. It could get a totally different result from and the process would be different. And they didn't have any kind of standardized data sharing agreements. So it was really frustrating for the tech. And on the state side, I mean, it became really clear pretty early on that there were certain challenges, like the state didn't have a complete understanding of the legal authority, not only of the tech, but also of ANTHC, which has a very unique legal standing as a result of federal legislation, as a public health agency for the feds. And their state had limited legal resources. It's not like they had a whole fleet of lawyers who could really dig into all of these really kind of complex issues of federal law, tribal data sovereignty, and EPI, the tech's federal rights, and state law, because that's a whole other layer that goes to it. So there was, on the tech side, there was a lot of frustration with the process. There was a lot of frustration, and the next example I give, if it relates to you, please sing out. Having their data requests that were for public health being treated as research requests, right, which has a completely different legal analysis as far as getting the data. So there was a lot of frustration. Some of the folks at the tech really were feeling disrespected as public health professionals. They felt that they weren't being treated on the same plane as their brother or sister epidemiologists at the state. And then I would also say that there was a bit of a lack of trust on both sides. There was some concern on the part of some people at the state that they didn't recognize that ANTHC was itself a HIPAA covered entity. So it already was bound by, HIPAA and privacy and had really strict security provisions and all of that. But because some folks at the state didn't understand that, there was a little concern of, well, what are they going to do with the data when they get it, right? And then there was also mistrust on the side of the tech, for a variety of different reasons also. So people wanted to do better and wanted to do it, but they needed help to get there, essentially.
So just with a show of hands, how many of you have experienced similar challenges in data sharing? If any of those resonate with, I'm seeing a lot of nods and hands around the room. So some similar things. So so walk us through kind of where you started then, right? So a lot of folks are experiencing similar challenges. There's a really complex issues here, both legally and in relationships.
Mm-hmm.
So where do you start, and what's kind of different about the approach that you took that allowed it to make more progress this time?
So, usually when you're going to negotiate a data sharing agreement, you put the lawyers in the room and they duke it out, right? Or, and the lawyers will have already spoken with their clients to get information. But in this case, there already was a history of working out some data sharing agreements. But again, they were very different. There weren't, they had a recent history of having negotiated a few data sharing agreements. I don't remember if it was YRBRS or, what the data pool was itself they were pulling from. But so they had made some progress recently, but not, but they didn't have enough legal expertise or resources basically to be able to really pull it over the line and finish it up. So the approach that we used was, the first thing was to meet separately with the tech and meet separately with the state. And by doing that, it gave each of them an opportunity to kind of speak freely about what have been the challenges and the barriers for data sharing in the past, what were the frustrations with it, and then also what were their goals for getting out of the data sharing agreement. What is it that they were looking to achieve through this process? So by each of them having the opportunity to speak freely about it, it actually became really clear pretty quickly. Some of what I was already saying, that some of it was just a question of sharing information with one side or the other about, for example, ANTHC's unique federal status that gives it status as a federal public health agency, right? Or it could be the state recognizing that within the tech, which is, the tech is actually a part of the mothership of ANTHC, it's a HIPAA environment. So that gave people a reasonable assurance is that, okay, it's in a safe, environment. It's in an environment where people are trained on how not to share data when you're not supposed to, right? So that kind of education was pretty easy, pretty early on. It was easy to see that some of it was just sharing information and sharing, and it was a neutral who was providing the information, right? The fact that I was in a neutral position, I wasn't representing the tech, I wasn't representing the state. I just came in with certain legal expertise and project management to help the two come together and bridge the misunderstandings or the lack of information. So that was the first part of it. The second part of it was, as soon as I had what everybody's priorities were, then my law partner and I dug into the law. So we basically developed a multiple page legal memo that laid out the authority, the legal authority of the tech and ANTHC as a public health authority to receive the data, and the legal authority of the state to share the data with other public health authorities. And then we also really dug deep into, I think it was 13 different databases, because you probably know that besides federal law, there's also state law. Sometimes there's state laws that'll speak specifically to okay, who can get the data from the cancer registry, or with whom can the immunization data collected by the state be disclosed to or shared. So we created a chart, basically. We did all of that legal analysis. Again, from an objective point of view, not advocating for one or the other. Our point of advocacy was to meet the goal of the state being able to share as much data as it possibly could with the tech, as legally permitted with the tech. And then we presented that legal memo to the lawyers for the tech and the lawyers for the state and asked them to critique it and see if we had reached if there was agreement or any disagreement on it. Unfortunately, there wasn't any disagreement on it. They agreed with our legal analysis. And that, again, it just opened the door up to removing a lot of the issues that have been barriers in the past.
So once you have a shared understanding of this is what the law says, then you can kind of move forward past all of the kind of historic fears and stress about kind of the uncertainty there. So I understand the next step then, right, is then taking all of that knowledge and turning it into a usable legal framework, right?
Mhm.
Can you tell us more about kind of what that means and what that looks like?
Sure. And actually there are slides. If you could advance 2 slides. There you go. That's the one. I want to stand up for this one. Here I go. Okay.
Make sure you grab a mic. You can take a table mic.
Yeah, okay. See, I got my way. All right, so it was a three, it was a 3 document, it was a suite of 3 documents basically that, we created. You know how, for anybody who's been involved in data sharing, negotiating data sharing agreements before, you know how it can take a lot of time to get like the really basic issues down. So one of the frustrations on the state and the tech side was that with every data sharing agreement, they had to renegotiate all the basic issues, whether there was legal authority to do this. And again, all the different issues. And again, without a policy that standardized how the state would treat the requests coming in, you went to a different door number 1, 2, or 3, you might get a different answer, right? So what we did was we created a so-called umbrella agreement as depicted by the umbrella. So the umbrella agreement has all of the basic terms that needs to be in a, that need to be in a data sharing agreement that you would negotiate every time. Like it cites the authority of the tech or ANTHC to have the data. It cites the authority of the state to share the data. It recognizes, I think we had language in there, well, recognizing sovereignty and, but then also like what we would call boilerplate kind of language too. And there was also, and this was kind of important too, that there was actually the statement of the state's desire to share the data with the tech, which, oftentimes that's, it's good to capture that, right? When it's a close call, give it to the permissive sharing of data. So that's the umbrella agreement. They negotiated, we drafted it, they negotiated it once, they don't have to negotiate it again. It will basically live in perpetuity. I think we put in the agreement that every 5 years, one side or the other can ask that it be reconsidered, but otherwise it will just continue on. And then with the umbrella agreement, what we also did was we created this middle line here, the blue line of the data disclosure appendices. So for each data system the state has, the cancer registry, the immunization registry, YRBS, I mean, all different, they're different data systems. When the tech wants to make a request, that's the bottom line here, is the third form was a data request form to standardize how they would make the request for the state to be able to take it in. Once the data request comes in for the first time from a certain data system, the parties would negotiate once the data sharing agreement for that data system. And that's where the more specific stuff would come in, like the frequency with which the data would be shared, the data fields that would be shared, whether it could be identifiable data or, it had to be de-identified or aggregated. So that's the idea of these data disclosure appendices. So if you think about it, what that means in the aggregate is that they don't have to keep negotiating the same stuff over and over again. And there were some economies of scale because one of the biggest issues for the state in particular is that they have limited legal resources, right? Like, how it's, if you want to get a legal agreement done, send it to the lawyers, that's where it'll go to die, right? So the idea is that this is a way to really maximize limited legal resources that the state in particular has, but also it's not like, the tech has ample, lawyer time to put into renegotiating the same thing over and over again too.
So now you have a legal framework that's clear, it can be consistent, but it's also very flexible across all of the different types of data requests that might come up.
Right, and a policy, I forgot that too. Besides the 3 documents, the state also created a policy and a procedure. So now they have a standardized way when the data requests come in from the tech. So they don't have this like a disparate treatment, who knows what you're going to get with the request.
So one of the pieces that I find really interesting in Alaska's process was that they brought was your role in it, right? Serving as this kind of neutral mediator between the two parties. And then I understand that in addition, ASTO, the Association for State and Territorial Health Officials, also played a role. Can you tell us more about their involvement?
Yeah, so I had met, it might have been at an NIHB conference, or I used to work for the Network for Public Health Law. It might have been at that conference. I met one of the folks from the state, and they heard Dr. Megan O'Connell, who's Chief Public Health Officer at Great Plains Tech. We were speaking together on a panel, and the state of Alaska came up to me and said, we need someone who can help us like get through this. We need a different way or a better way to deal with this. So they found out that ASTO would pay out of the Public Health Infrastructure Grant, the FIG money, would support the state in its effort of hiring someone, me, to come in with the legal expertise and project management kind of skills to help them get it over the line, get the project done. So that's how ASTO came into it.
So roles for lots of partners to help this process along. So can you tell us more about kind of what Alaska in some ways is a kind of a unique situation, right? There's a lot of things that are kind of special about Alaska. Can you talk a little bit more about maybe what other tech or tribal scenarios that you think this approach and legal framework might be really useful for?
Yeah, so I thought about this some, and I think, yeah, Alaska is definitely, I know there are some states that are very open to and have good relationships, right, with their techs and their tribes, and they have wanted to share data. Maybe they haven't felt they could because of restrictions on state law as much as the tech may have wanted or something. But for the states that have a good relationship and, want to be able to share more data with the tech, this might be a good way to go about it, right? Where there's not antagonism, where there isn't a bad history, between the parties, they might be open to that. In particular, a state might be open to it if, as I say, if they have limited legal resources, right? Like one of the benefits of having a consultant come in is, someone with legal expertise about data sharing, access of techs and tribes to data, and already knowing about the tech, federal authorization to be a public health agency, already knowing that HIPAA applies to tribe, they recognize as a public health authority, and techs are recognized as a public health authority under HIPAA, that kind of thing. So some of it is, I think, it's a benefit, like if there's a recognition that we could use some extra legal power to help us kind of navigate some of these issues. I also think that even if it's not a good relationship necessarily, or one that already has good data sharing between a state and a tech or a tribe or a tech might want to come in with some bigger guns, legal guns, I guess you could say, you know what I mean, to be able to negotiate strongly with a state, to get the data. And there may also be, I was also thinking a little bit about if there's, where there's a long history, maybe that's not warm and fuzzy between a state and a tech. A state and the techs or the tribes that are looking for the data, having a neutral party come in may help deal with the dynamics, of kind of like everybody go to your corner, right? And let's just hear what everybody wants, and then we'll find a path to that. So those are the ones that occurred to me.
So kind of for those in the audience, are there any pieces there that are resonating, that sound like they might be useful for you? Kind of, I'm seeing some nods. Like, are there any? We can take some questions from the audience too. Are there any questions for Chris? How the process works, advice, or sharing your experience?
So can you tell us a little bit about how do they initiate that? Is that something that you explain to them would be easier to facilitate down the road, or is that something that they already had in mind?
It was early on, like before I became a part of the project in the state, that had been my suggestion that they consider doing that. It's not my idea. It's a construct that exists in other forums too. So it's not like I was had a moment of brilliance. It was not mine. But it really applies very well to this kind of situation because so much of the data sharing has exactly the same issue. So why relitigate? Why have to renegotiate everything? If you can do that umbrella agreement once, especially because that was a lot of the hard stuff about getting the hearts on the same page, essentially about, do we have an agreement or not? Do we want to see both public health agencies in the state of Alaska doing their best work because they can share the data with each other? There was like that commitment. So that's what was captured in the umbrella agreement.
Was there another question on this side? There in the back, yeah.
So I know that these documents are specific to Alaska and Alaska law, but I'm just wondering if it would be possible to look at them and just sort of see what the structure is and just sort of try to wrap my mind around more. Is that a thing that could maybe happen?
So they're not my documents.
Yeah.
They really belong to the tech and, the state. But I did ask, and the other thing I wanted to mention, I was going to say is that the process is working. They've already negotiated one data disclosure appendix and it's like, yippee-ki-yay. And they're in the middle of a second one right now, I think for YRBS data. But when I reached out to the state to ask them, if people wanted to follow up and talk with you, would you be willing to chat with them about it? I'd be happy to put you in contact because they said yes. And I'm sure people here have connections with the tech. You could just call up Larita, if you know Larita, or Lowry Ward was someone else who was also involved in that, or call the lawyer, Peter Reckmeyer.
Do you have other resources?
Yeah, so I actually, ASTO, one of the deliverables for the ASTO money was creating a summary of the project, the whole process. And then also a second document, which was kind of for me, it was kind of like a brain dump for me of basic advice for data sharing agreements, particularly in the context of state sharing with techs and tribes, recommending that the lawyers for the state do the work ahead of time and read the article that you guys wrote on tribal sovereignty, public health authority, and that to educate themselves so it doesn't have to be slow down the negotiation. Another piece of it was not starting with their own boilerplate, the state not starting with their own boilerplate agreement because that's already biased towards one party, It's a different way. That's not how we're trained as lawyers to negotiate things, but it's a different approach because it's a different relationship, right? And that is, I had asked ASTO if I could, where it was going to be online. So once it's published, loosely defined published, available online, I'll let you all know, but it's not online yet.
And yeah, we can link that when it's available through the data symposium page. So, and I think there was one more question here. As answered. Okay. Okay, we could, last one.
Hi, so Abigail Ekwak here. I was blessed to be able to have some consultations in regards to this project as it was going on. If you could speak to a little bit about the expansion of the definition for ANTHC in regards to the data of American Indian and Alaska Native. And so initially when they began this project, they had a very kind of singular definition, which limited the amount of information and data in which they were able to think about within the data sets that they're negotiating with the state. And then they changed their definitions to be more inclusive based on some guidance actually that the Urban Indian Health Institute has put out in our best practices on American Indian Alaska Native data collection. And so if you were involved in that, I think it's a very important thing to think about because when you have an expansive definition that captures all of your relatives, you're going to have a much more robust data set that allows you to do better statistical analysis as a result of a larger sample size. And then I do want to offer one clarifying thing is that in this instance, we're talking about Larita, who is now the director of the Tribal Epidemiology Center, but every Tribal Epidemiology Center is under the governance of a tribal organization. And so ANTHC is the governance over the work that Larita and team does across every other tech. And I think there have been misunderstandings that tribal epidemiology centers operate on their own, and they do not. They are all part of governance of tribal organizations that have tribal leadership that govern the way that these tribal epidemiology centers function, which is why we are considered tribal public health authorities and why that expansion under the Affordable Health Care Act in 2010 included us as public health authorities. So it's a really important distinction to know that, for example, Larita, who's absolutely incredible, is not operating on her own and has tribal governance over what she's doing, which is why that tribal governance assisted in what does it look like for that expanded definition. And I know the team at ANTHC saw a significant increase in the sample sizes across the different data sets that they had access to as a result of that expansive definition, which was a negotiation with the state because it hadn't been done before.
So a few things. I absolutely have the same appreciation, understanding that you just explained for techs do their work in consultation with tribal leadership. And that was actually part of the education that we did at the state, is looking at and explaining the data governance structure for ANTHC, which is I think it's 17 or 18 other regional health consortia all have voting rights on ANTHC's governance board. And then I think the tribes that are unaffiliated also have 2 votes on that board. So yes, Abigail, that's exactly my understanding also. And there was no question of that from the techs. There was never raised any question about whether the tech was stepping out, outside of its authority within the community of, Indian community. The definition part, I actually don't remember us having any discussions of that, because I thought where you were going was there's often an issue of some states saying to techs or tribes, you can only have the data of the Native Americans or the Alaska Natives. And in this agreement, it was recognized that they could have the data you need to have to do your work, which is not limited to American Indians or Alaska Natives. So as anybody who does population health, and as I've learned from the people who do population health know, you need to have more data than just that limited population. So Abigail, I don't know if that's what you're going to, but I don't remember.
It was, yes. So I
Okay.
appreciate that. And the reason I'm really glad that you expanded on that is that we're playing perfectly off each other, is that we have an opportunity as American Indian Alaska Native communities to expand and think about the communities we are in relationship with, whether it be in our counties, in our boroughs, in our villages, our reservations, to utilize and understand our health and well-being, not as a comparison to see who's doing better, but rather who is doing well and where there are gaps for all of us, because our health comes together. And right now, there is a hardship in getting access to appropriate data across all populations. And Indigenous communities, American Indian Alaska communities, as a result of the legal stance of Indigenous data sovereignty, have access to information such as this that ANTHC has that could be utilized in relationship and partnership with other communities. And thinking about ourselves as not a public health community that only focuses on the health of, let's say, my family and I. My family and I are in a neighborhood that there is not another Indian within like a mile, around like a square mile. But I am surrounded by other communities that contribute to the health and well-being of me and my children. And so we have an opportunity to be able to utilize those comparison groups and calculate information about how we're doing in comparison of wellness, not in comparison of who's the worst off. And so it also gives us the opportunity to use tribal sovereignty, to use tribal public health authority to benefit our communities, and I mean the communities we live, breathe, work in as a whole, not just, we have the health of our communities in our hands, and the data gives us opportunity to do so. And those comparison groups can be very important, not only for us, but for the other communities who right now may not have access to any of this data.
So the other,
This is a
I have
great
to-
way to end.
I have to make
It's-
one clarifying point. I just have to make one clarifying point,
Very-
which is that because states often are concerned when they hear the idea that they get to have every data, just to remember that there are state laws that sometimes require the data be de-identified or that it be aggregated. So it's not like the floodgates are open for anything and everything. There has to be you know, why is it being used? It has to be for public health purposes, you know, that sort of thing. So I just wanted to clarify in case
And
anybody. in
sorry,
Alaska
Rochelle,
was sitting home
and the techs
thinking about-
have stronger guidelines for that than the CDC does. That's one thing I'm most proud of. The techs are incredible.
Woohoo. That's a great way to end, I think. Thank you so